There is a moment that happens thousands of times every single day on roads across this country, a moment that most Americans are completely unprepared for, not because they are criminals, not because they have done anything wrong, but because nobody ever told them the truth about what happens in the next 10 seconds after a police officer leans into your window and asks you one specific question. James Carter had been a responsible gun owner for 22 years. Clean record, legal permit, firearms stored exactly the way his state required. He had done everything right, everything by the book. He was driving home on a Thursday night in April of 2026 when he got pulled over for a broken tail light. A broken tail light, that was it. That was the only reason those blue and red lights came on behind him. He pulled over immediately, turned on his dome light, put both hands on the steering wheel. He was calm, cooperative, and completely prepared to take his ticket and drive home. And then the officer leaned in, glanced around the car, and said 4 words. 4 words that James had never been warned about. 4 words that most gun owners hear and answer without thinking. The officer said, "Is that your gun?" And James answered. He answered the way most good, honest, law-abiding people answer. He said yes. He explained it was legal. He reached for his permit. And in the next 4 minutes, James went from a man getting a taillight ticket to a man sitting in handcuffs on the side of the road while officers searched every inch of his vehicle without his consent, without a warrant, and without any legal right to do so under a ruling that James never knew existed. He was not arrested that night, but his firearm was confiscated. His permit was flagged. His name went into a system. And 3 months and $11,000 in legal fees later, James got his gun back and an apology from the department that meant absolutely nothing. That happened because James did not know what the Supreme Court of the United States had already decided on his behalf. A unanimous decision. 9 justices, 0 dissents. The most powerful court in this country looked at exactly this situation and said clearly, you have the right to protect yourself from that moment. And almost nobody is talking about it in plain language. My name is Ray. I have spent years watching cases like James's move through the legal system from the inside. I have seen what happens when good people give the wrong answer to the wrong question because nobody ever prepared them. And that is exactly what this channel exists to fix. If you want to understand the rights this country guarantees you before you need them, not after, hit that subscribe button right now. Because what I am about to walk you through is the kind of information that changes outcomes, real outcomes, on real roads, for real people. Let us start with what the Supreme Court actually decided, because this is the foundation of everything. In a consolidated ruling handed down in March of 2026, the Supreme Court addressed a question that had been building in lower courts for years. The question was simple and it was devastating. Does the presence of a legally owned firearm in a vehicle give law enforcement automatic authority to search that vehicle? Courts in multiple states had been quietly drifting towards saying yes. The reasoning went like this. Firearms are dangerous. A firearm in a car creates a risk to officer safety. Therefore, any traffic stop involving a firearm can be elevated into a search situation regardless of whether any crime has occurred. Follow that reasoning to its conclusion and you arrive somewhere that should alarm every single person watching this. If your legal firearm automatically triggers search authority, then exercising your Second Amendment right simultaneously destroys your Fourth Amendment right. You cannot have both. The moment you legally carry, you legally surrender your privacy. That is not what the Constitution says. That is not what any honest reading of those documents has ever meant. And the Supreme Court said so, unanimously. 9 justices, Roberts, Thomas, Alito, Gorsuch, Kavanaugh, Barrett, Sotomayor, Kagan, Jackson. Every ideological corner of that bench looked at this situation and arrived at the exact same conclusion. The mere presence of a legally possessed firearm in a vehicle does not by itself constitute probable cause to search that vehicle. Read that again, slowly, because those words just built a legal wall around you, and most Americans have no idea it is standing there waiting to protect them. Armed does not mean criminal. Lawful carry is not evidence of a crime. And law enforcement cannot use one constitutional right as a weapon to strip you of another. Now, here is where most people watching this make the mistake that turns a powerful ruling into a false sense of security. They think this ruling is a force field. They think the next time an officer asks about their gun, they can just wave this ruling around and the conversation ends. It does not end there. The ruling has 3 specific trap doors built into it. And if you do not know where those trap doors are, this ruling will not help you when you need it most. Trapdoor number 1. The ruling protects legal possession. If you are a prohibited person, if you have a felony conviction, a domestic violence restraining order, or any other disqualifying factor on your record, this ruling provides you 0 protection. The gun in your car is not a neutral detail in that situation. It is evidence of a crime, and the officer does not need anything else. Trapdoor number 2, the ruling protects legal storage. Every state has specific requirements for how a firearm must be stored inside a vehicle. Some require the weapon to be unloaded. Some require a locked container. Some restrict which area of the vehicle it can be located in. If an officer can see your firearm stored in direct violation of your state's storage law, the 9-0 ruling does not apply. He is not searching because of the gun. He is searching because of an observable criminal violation. The gun is still legal. The way you stored it is not, and that distinction will cost you everything if you do not know your state's storage requirements before you put the car in drive. Trapdoor number 3. The ruling stops a legal firearm from being the sole justification for a search. It does not stop officers from using it as one factor among several. Picture this. You get pulled over. You have a legal gun, but your passenger is acting nervous. There is an odor in the vehicle. You give inconsistent answers about where you are going. The officer is not going to say he searched because of the gun. He is going to say the gun combined with the smell, the behavior, and the inconsistent statements collectively created probable cause. He may be legally right. The Supreme Court ruling does not abolish the automobile exception to the Fourth Amendment. It stops one specific thing: the use of a lawful firearm as the only justification for a search. Every other factor at that stop still matters. So now we get to the question this entire video is built around. The officer leans into your window, looks around, spots your firearm or suspects you have one, and says, "Is that your gun?" Most people think they have 2 choices: tell the truth or lie. And I am here to tell you that both of those options, executed the way most people execute them, are catastrophic. Let us start with lying. You panic. You think it is easier. You say, "No, officer, that is not mine." You figure the stop ends there. Here is what you have just done. In most jurisdictions across this country, making a false statement to a law enforcement officer is a criminal offense. It does not matter that your gun was legal. It does not matter that you were trying to avoid a confrontation. The moment you lied, you handed the prosecutor a gift. If that officer develops any reason to search and finds that gun, you are no longer dealing with a traffic ticket. You are facing obstruction charges, false statement charges, and your legally stored firearm has just become evidence in a criminal case against you. Your credibility is destroyed. A jury will hear that you looked a uniformed officer in the eye and lied. That is how innocent people end up with records. Now let us talk about the truth, because most people think honesty fixes everything. You say, "Yes, officer, that is my gun. I have a permit. It is right here." You think you have done everything right. Here's what you have actually done. You have just told a trained law enforcement officer there is a weapon in the vehicle. Every instinct and every hour of training that officer has received now activates. This is no longer a taillight stop. This is what their training categorizes as an armed encounter. They will ask you to step out. They may put you in handcuffs for what they call officer safety. They will ask to secure the firearm. They will run the serial number. They will ask where you are coming from, where you are going, whether you have any other weapons. And every single answer you give, every piece of information you volunteer, is raw material for an investigation that should never have started. You tried to cooperate and you walked yourself directly into a situation you cannot control. So if lying is a crime and full disclosure is an escalation, what does the law actually give you? The answer is not complicated. It is not hidden. It is sitting right there in the Constitution that every American child is supposed to learn about in school, but almost nobody learns how to actually use. Here's exactly what you say. Here is the script. 2 steps. That is all. Step 1. When the officer asks, "Is that your gun?" You look him in the eye, you stay calm, you stay polite, and you say clearly, "Officer, I don't consent to any searches." That is it. Read that back. Notice what it does. You have not said yes. You have not said no. You have not lied. You have not admitted anything. You have not been rude or combative. You have used precise, legally recognized language to invoke your Fourth Amendment right. That sentence tells the officer everything he needs to know. That you know your rights, that you are not going to be pressured into a consent search, that any further investigation is going to require actual legal justification. It stops the entire situation right there. The officer now knows he cannot rely on your cooperation to build a case. He needs real probable cause. And simply refusing a search is not probable cause. It never has been. It never can be. Refusing a search is the exercise of a constitutional right. It is no more suspicious than refusing to let a stranger read your personal mail. Now, the officer may push back. They are trained to push back. They may use the classic line, "If you have nothing to hide, why won't you let me look?" Do not take that bait. Do not argue. Do not explain yourself. Do not get philosophical. You do not owe anyone an explanation for exercising a constitutional right. Stay calm. Stay quiet. Hold the line. Step 2 comes immediately after step 1. You follow up with one direct question. Officer, am I being detained or am I free to go? This is not aggressive. This is not disrespectful. This is a legal checkpoint that forces clarity. If the officer says you are free to go, thank him, roll up your window, and drive away. Do not say another word. You won. If the officer says you are being detained, the situation has formally changed. He has now made a legal claim that he has reasonable suspicion of criminal activity. You respond with one final sentence. Officer, I am exercising my right to remain silent and I would like to speak to a lawyer. And then you stop talking completely. You do not explain. You do not justify. You do not answer one more question. The conversation is over. You have built a constitutional wall around yourself and it is built from concrete. Now here's the piece that catches even careful, educated gun owners completely off guard. And this is the part that most channels will never tell you because it complicates the clean narrative. Duty to inform laws. Some states in this country require you to proactively tell an officer you have a firearm during any official encounter, not when asked. Proactively. The moment the encounter begins, Ohio requires it, Michigan requires it, Texas requires it, Louisiana requires it, several others. In these states, silence is not protected. Silence is a criminal offense. If you are in a duty to inform state and you have a firearm and an officer pulls you over and you do not immediately disclose, you can be arrested. Not because you did anything violent, not because you were dangerous, because you did not speak first. If you are in a duty to inform state, here is how you modify the approach. The moment the officer engages you at your window, before he asks anything, before you hand him your license, you say calmly and clearly, "Officer, I want you to know that I am a permit holder and I have a firearm in the vehicle." Then you stop. You have done exactly what the law requires and nothing more. You have stated a fact. You have not given consent to anything. You have not invited a search. And if that officer then asks where the weapon is or says he wants to secure it, you revert immediately to the original script. "Officer, I don't consent to any searches. Am I being detained or am I free to go?" Then there are states like Florida, Georgia, Virginia, and others with no duty to inform requirement. In these states, you have zero legal obligation to volunteer information about a firearm unless you are directly asked a question that you cannot honestly answer without mentioning it. In these states, the script I gave you is your complete protection from the moment the lights come on behind you. The problem is that millions of Americans cross state lines every day without knowing which category they are in. They assume the rules are the same everywhere. They are not even close. And that assumption has put innocent, licensed, responsible gun owners in handcuffs. Not because they were criminals, because they did not know. Here's what you do right now before this video ends. You look up your state's duty to inform law tonight, not tomorrow. Tonight, you look up your state's vehicle storage requirements. You write down these 2 sentences and you put them in your phone. "I don't consent to any searches. Am I being detained or am I free to go?" You say them out loud until they come naturally. Because under pressure, with blue lights in your mirror and a flashlight in your face, the words you have practiced are the only words you will actually remember. And you share this with every gun owner in your life. Because the most dangerous gap in this country right now is not between the laws that protect you and the laws that threaten you. It is between the rights that exist and the people who do not know they have them. The Supreme Court ruled 9-0 in your favor. 9 justices who agree on almost nothing agreed on this. They said your Second Amendment right and your Fourth Amendment right stand together. You do not have to choose. You are entitled to both at the same time, without condition, without having to prove yourself to anyone on the side of a road. But that ruling only protects you if you know how to use it. And now you do. Subscribe to this channel. Turn on notifications. Because when the next ruling drops, when the next state passes a law that affects what happens at your next traffic stop, you will hear about it here first. Not weeks later. Not after it is too late. Drop a comment below and tell me what state you're in and whether you knew about duty to inform laws before watching this. I read every single one. Because the conversation in this community is how we stay ahead of what is coming. Stay sharp. Stay informed. And the next time someone asks if that is your gun, you already know exactly what to say.